Hi, Tim.
How's it, John?
I'm well, and you?
Good. Always nice to see you.
It's always a pleasure. You used to work for the National Credit Regulator. Maybe tell us more about yourself and your experience and perhaps even qualifications.
Thank you. I'm Timmy van der Grijp. I was the legal advisor at the Debt Counselling Department of the National Credit Regulator. I'm a lawyer of profession. Did a BProc, then did an MBA, and also got certifications from the University of Cape Town on business risk management, and a certification on sustainability from the University of Cambridge.
Okay.
Was at the regulator for 3.5 years, custodian of debt review and everything relating thereto. And also were responsible for the registrants, the debt counselling registrants, their needs within the industry, and also their compliance. So, all-rounder in debt counselling, and I see myself as a specialist. I left the regulator in March, and I am now running my own consultancy to the credit industry, specifically targeting the debt counselling industry as well as the micro-lenders.
Yeah.
So very active in that space at the moment.
Okay. I'm excited about the fact that we're talking to a lawyer on debt management issues and all things credit management. Very often we talk to people about, things relating to debts, but you find that they don't necessarily have a legal background. I'm not saying that's the prerequisite to speak with authority on the subject. I mean, you can be a practitioner, but it's always a pleasure to actually talk to somebody who's legally trained to deal with some of these issues, because some of the things we're going to talk about today range from debt collectors and the rights of consumers, as far as people feeling that they're being harassed by debt collectors. We would talk about can debt expire, because people get calls from debt collectors as well about debts that they've even forgot because it's something that happened a couple of years ago, and things like even debt counseling, debt consolidation, and also people complaining about being overcharged with their debts. I mean, a person borrowed 10,000 rand, but then it seems like the credit provider has now added more costs and interest, and now they end up owing 40,000. So, and people are wondering, but how is that possible? But also maybe things around the credit bureaus, the credit score, how that works, and how, I know people are still using the word blacklisted. When there's an adverse listing, I mean, how long should that record stay on the credit record? Those are some of the things that we'd like to talk about. But I want us to start with issues of debt collectors. I mean, a lot of people complain that I'm being called by debt collectors. Some of them are calling at ungodly hours. So maybe if you can talk to us about that, to say what is fair and what are the rights of consumers. We're not saying people shouldn't be paying their debts, but to the extent that, when consumers get to a point where they feel I'm now being harassed and I feel helpless and defenseless, what are your views on that?
I think let's start off with, I think we need to be very clear that a consumer at all times is responsible for his own financial well-being.
Yes.
So consumers need to be honest with themselves when they take on debt specifically, and they need to be honest with themselves if they can repay it. Also, there's an issue which we can touch on taking bad debt or taking good debt. I mean, that is very important, in the credit industry, and that would dictate how you would interact with that credit over the period of its lifetime. So I think that is the most important thing to start off with. A consumer must take responsibility for their debt. I mean, they receive the money and they need to repay it.
Yes.
And when we start looking at debt collection and debt collectors phoning you, it means that there was a default in the debt, and it means that that default needs to be cured. And remember, credit providers built their models, their business models, and they're allowed to make money. And that's what they do. And they built their business models on the recovery of their capital. So they would do then whatever they need to do to recover it. But now, remember, we're not in the Wild West anymore, where the guys with the baseball bats come and knock on your door in the morning for their debt. So the Debt Collectors Act is there. The Act is very clear as to the registration of debt collectors, the qualifications that they're required to have, the supervision that they need to give to the people that work under them. And auxiliary matters, such as the time that they can call you. That is very specific.
Maybe talk to us about that. I mean, at what point do they get to the point where they're perhaps starting to cross the line, and what are the rights of a consumer? But obviously, having taken into account what you said about the consumer is responsible for their debt. They borrowed the money, and therefore you must pay.
Indeed.
But however, it doesn't mean people cannot be perhaps abused, if you like, if I may use that term, in terms of the conduct of debt collectors. The fact that they need to be registered, surely there must be some rules that governs their conduct as debt collectors. What are those?
Well, that's in the Debt Collectors Act. It's a recent act, if I can recall. And there's also the mother body, the Debt Collectors Association, which is like the National Credit Regulator, whereby consumers can lay complaints. Of any sort, harassment or whatever. But certain rules, I think 7 to 7 is a godly hour to contact anybody. I recently had an experience where a debt collector had my number for not my debt, and these people were just not listening. I feel the debtor's pain, because taking a call at 8 o'clock at night, thinking a family member is in danger somewhere, just to be spoken to rudely, a person that you don't owe the money to. So I can relate. I can relate very clearly. And so 7 to 7 is godly hours, if I can call it that. Cannot harass you at work. That was.
So meaning they can't necessarily call you at work or with your lender? What does it mean?
Or come to your work to collect your vehicle,
so
for an example.
They can't come to your workplace? Is that what you're saying?
Yeah.
Okay.
And the Debt Collectors Association is very active. At the Credit Regulator, we work very closely with them. They attended days, workshop days and so on with us. Because with debt review and debt collection, there is a very close synergy, because from the harassment that consumers normally get under the debt collection umbrella could be cured by debt counselling. So if the consumer then would take the step into debt counselling, it is a means and a very effective means of taking away the harassment from debt collectors, and as well as the stress under which consumers find themselves when they are in default. And unfortunately, the longer you get into default and stay in default, the more the efforts of the debt collectors would be to collect that money.
Absolutely. So you said something like they can't come to your work to try perhaps collect your car. Can they call you using the landline, your work landline?
I can't recall if there's any specific issue surrounding that. But it will also be within reason. Calling you every 10 minutes at work when you're on the switchboard. That's not within reason. But again, any consumer that feel aggrieved is very welcome to contact the Debt Collectors Association.
So can a debt collector go to a person's workplace, present them with forms that they need to complete for whatever reason that they would advance to a consumer?
I don't think that would be proper. This is a place of employment, and this is not a place that is connected to the debt at all. I'm sure that the consumer would not have selected their work address for the services of documents. That would normally be in your domicilium, being your home. So consumers need to look at the addresses that they choose. If they
Yes.
chose their work address as the delivery
When
of
you're applying
documents,
for debt, yes.
that's a different story, because then they act within their means. But if it's an address that the consumer did not select as a domicilium, it would be improper.
Let's talk about prescribed debt. Can debt expire,
Oh
legally
yes.
speaking?
Oh yes.
How?
There's two ways, or three ways actually. Firstly is the Prescription Act, and I think it is of 1968 or 69, I can't recall. And it sets out very clearly what type of debt can prescribe over what period. So if there is a judgment against you, that judgment would only prescribe in 30 years.
30 years. And I guess that's predominantly for your mortgage, predominantly, I guess.
Oh, no. A mortgage is a completely different section in prescription, and that also falls under 30 years.
Oh, okay.
And tax, of course.
You're saying if it's a judgment,
If there was a summons issued,
Yes.
and the court has granted judgment against you,
Yes.
that will stand for 30 years
Yes.
before it prescribes.
okay.
Okay?
Yes.
This should not be confused with the
Retention
listing
periods.
of it on the
Yes.
credit bureaus.
That's right.
Because there was an amendment to the Act, the Credit Act in 2014, which clearly indicated prescription periods relating to credit bureaus. So, for an example, a judgment on the credit bureaus can only be reflected for a period of 5 years.
5 years.
It doesn't wipe the debt away.
Yes, yes.
It's just the listing
Yes.
that would be falling off the credit bureau within a 5-year period.
Yeah. So in other words, if there's a judgment against your name and it is listed on the credit bureau, on your credit report, it can only remain there for a period of 5 years, but it does not necessarily mean that your debt just disappears, but it just simply means in terms of the credit bureau and your credit report, it legally speaking, it may only remain there for a period of 5 years. But when we're talking prescription, we're talking about debts that can expire. So let's talk about the common ones, which is your clothing account, your personal loans. So maybe explain to us what does it mean when we say debt has prescribed, legally speaking?
Okay. The Prescription Act is quite clear on that, and I think you're specifically referring to the 3-year debt.
Yes.
So those would not be negotiable instruments or loans to the state, which has different prescription periods, but normal debt would prescribe in 3 years. The Act is very clear that the consumer then made no payments within the 3-year period on the debt, and that there wasn't an interruption of the prescription. So an interruption would mean that you were out the country for an extended period of time. So from the time when you leave the country, the prescription will be halted, and when you're back in the country, it will then start running. Or if the debt collector, for an example, phoned the consumer, and the consumer said, "You know what, I owe you the money, I know, I'll get to it next month, phone me next month again." When the consumer said, acknowledge the debt, then that prescription period will start afresh.
Yes.
But if a period of 3 years have passed, and there has been no payment, one, and where there has been no acknowledgement of the debt, the debt would then prescribe. The credit bureaus are geared for that. They have last payment dates that is reflected on the credit bureau reports, and credit providers as well. After the 2014 amendment, undertook on the certificates of balance that they would provide to put there a prescription indicator to say this debt has prescribed or the debt is not. And it's quite an interesting story surrounding that. In the 2014 amendment to the National Credit Act, Section 126B was brought into effect, which says that if a debt has prescribed, so the 3 years have passed, there would be no payment or no acknowledgement, then the debt cannot be reactivated. Now you'd recall, you the legend, John, has been around forever, and you recall 2008, 2009, some of the gym contracts
Yes.
that has prescribed in the 90s. you know, where the companies that bought the debt just paid 10 Rand, you know, on it and reactivated so-called the debt. And the legislature was quite alive to this in 2014 when the amendments and the regulations were finalized. In Section 126B says you cannot reactivate. If it's dead, it's dead. Not like in the past, you know, when you look at the common law reactivation of debt. So with regards to credit, it's now been codified that it cannot be reactivated and it cannot be collected, and a debt collector cannot continue to collect thereon. And in the 2019 amendment to the National Credit Act, which is not assented to law as yet, they're still busy with the regulations, it even makes it an offence, and you can be charged as a credit provider or a debt collector if you are collecting or continue to collect or try to reactivate prescribed debt.
Yeah. So I want to simplify it for a viewer or a listener of this podcast to say, when we say a debt has prescribed, we're talking about debt that you would have had over a period of 3 years where you have not paid and there's been no attempt from the part of the credit provider, whether themselves or via a debt collector acting on their behalf, where there's been no attempt to collect the money or to contact you or even send you summons. So over the period of 3 years, that debt has prescribed, or in simple terms, it has actually expired. The most important thing is that the credit provider needs to make every effort to collect the debt. It can't be a case where they keep quiet and interest keeps piling up on that credit, and then they want to come up after 4 or 5 years and say, oh, by the way, you still owe us. Maybe tell us, where did this whole thing about Induplum rule come from? I mean, where does it originate from?
Well, the Induplum rule comes from the old East India Company times, the Spanish acquisition times, where the ships would go from Europe around the Horn of Africa or around the Cape, and would go up to India to go collect spices and whatever they would get. And these trips could take very long. So it came to a point where the ship would go to India, come back to Europe, and the money that was borrowed to the ship's captain from benefactor, and the interest that was charged on it would be so tremendous that the ship and the ship's captain would not make any profit from it. It was then decided to bring into law the Induplum rule, where it says that the money that was borrowed to you and the interest charged thereon cannot exceed double the amount of the original amount that was owed to you. This then would make these type of trips that take very long and is very labor intensive, would make these trips then profitable for these ships to move, because they just said, well, we're not making money, why must we go and do it? So, you know, that's really the, you know, where it comes from. And from there it spilled into the law as it was generally applied to everybody. And it spilled into credit, which has not been in the form that we know it today around for much longer than 150 years. It is a controversial type of rule in our law today. There are two conflicting decisions, High Court decisions on it at the moment. And I know that the credit regulator, in terms of Section 14, has been asked to step in and bring a declaratory order to get clarity on these two conflicting decisions. So I think the issue that stands is that the interest cannot exceed double the capital amount. That's not the issue in the conflicting decision. The issue in the conflicting decision is, does it include the cost of the credit provider to collect the debt? So the one judgment says that it doesn't. It's just purely interest and costs from the date of default. And we can do a whole series on what the date of default is. And the other judgment in our law currently says that it would include the cost of recovery, interest and cost of credit, cannot exceed double the amount. I think the principle is clear, that whatever interest you are charged cannot exceed double the amount of the capital from date of default.
Okay. So in other words, if I borrowed 5,000 Rand and the credit provider adds interest over time, that interest cannot exceed the capital amount. It cannot exceed 5,000 Rand.
And the cost of credit, eh? So,
yes.
so monthly charges and so on.
Okay. But then there is, as you said, there is a conflicting judgment from the High Court, which the National Credit Regulator has been asked to intervene to perhaps apply for a declaratory order to bring clarity on those two conflicting judgments. Okay, so I think we're clear in terms of in Dublin rule. Let's talk about the issue of adverse listing. I think the colloquial term is blacklisting. A lot of time people don't understand. I often hear people say, yeah, these people, they've taken me to credit bureau. But in essence, everybody who's got credit has applied to be on credit bureau. What is the purpose of the credit bureaus?
Credit bureaus is to hold information. And remember, there are 47 different credit bureaus registered with the National Credit Regulator. So if you want to see if they're registered, just go on their website, ncr.org.za, and they've got a section there on registrants. You click on registrants, and then it asks you, do you want to see a debt counsellor registrant or a credit provider registrant? Because remember, they all have to be registered with the National Credit Regulator to operate. And credit bureaus are also registered, as credit providers would. But a lot of them has got different roles. One would deal with rental defaults only. Yes. So would record rental agreements and would then record defaults. So if you get a tenant that wants to rent your property, you go on this credit bureau, you pay a fee, I don't know what it is, and you can see if this is a defaulting tenant. Okay. So from that perspective, it's a risk mitigation database that is maintained by these companies, obviously for profit. Yes. There's only 5 credit bureaus that deals with specifically with credit. One has just been sold and is amalgamated, so I don't want to put some names out there because I don't know what they're going to be called. But they keep credit information so that you as the credit provider can mitigate your risk on default on those agreements. So it would keep what agreements you have that's currently active, what is your last payment that you made, what is the installment, what is the interest rate, so that a credit provider that gives an additional loan can have access to what the current exposure is of the consumer with regards to debt versus their income, and then to make an informed decision if that consumer would be able to afford the debt that they're applying for and to repay it. So that is really the purpose of it. There are also resellers of information, but they need to be registered as such. But like I said, there's 47 different credit bureaus, so, and a lot of them has got different functions.
So what is a credit score and what is the purpose of having a credit score?
It's an interesting story. The credit score was normally used, it's an algorithm that credit providers run in the background based on your personal information, based on your credit bureau information, based on your income, the amount of time that you've been employed, and a whole bunch of stuff that they look at to internally judge if they fall within the risk parameters of such a credit provider. And for many years and decades and probably millennia has been in the background. It's been an internal scoring or risk mitigation type of thing that's only come into the general society in recent times, and I'm talking in the last 10 years or so. And it really just records your credit worthiness. Yes. So, you don't need an app to check your credit score if you have a judgment for debt against you. Because without looking at any credit score that you will not be qualifying for debt, because you will be in a category of consumers that would not qualify for debt. If you have, today with AI, it's unbelievable, the AI today. you know, those would pick up all the sorts of things. How much money do you have left at the end of the month after you've paid everything? All your debit orders went off, and you know, how much money you have disposably available. And that would really dictate how high your credit score is. And you know, as a consumer, if you have defaulted on debt currently, you don't need a score to tell you that credit providers are not going to assist you with debt. And I think it's very important at this stage to tell consumers that if you need to start taking debt to pay debt, the slope has started for you. Either uphill or downhill.
Yes.
And once you are at that point, it is time to start looking for professional help. And it's time to realize that you now need to take responsibility, because that is the turning point in any sort of financial wellness, is when you need to borrow debt or borrow to pay debt.
So what influences your credit score?
It would be a whole bunch of things. Obviously, your employment, the level of your income. It would be the size of the debt that you're currently carrying. You know, if you already got 80% of your debt that is payable every month, or 80% of your income that's payable every month to debt, there's no room to move. Because if you look at the reasons for default, the first reason is very simple. Either I use this money to buy food for my family, or I pay this micro loan that I have. What are you going to choose? I mean, I'd rather pay for food than pay for credit. And when you sit in a position where you do not have enough money at the end of the month to look after your family, that is where debt default starts.
Yes.
And that would have a great influence on your credit score.
Yes.
Do you have the disposable income available to look after yourself and your family while servicing your debt?
Yes.
And obviously then defaults. Were you in default? And that is a big part of credit bureaus. When I do a lot of teaching and I do a lot of mentoring, to teach a student how to read a credit bureau report is one of the more difficult things around there, because it obviously records your defaults, and if you were in default for how long, and all of that would influence your credit score. So if you are not in default with your credit agreements, you have a good disposable income, you have a steady job, and you don't have any judgments, you will have a good credit score.
Okay. So then you've got these adverse listing, things that people call a blacklisting. What are the retention periods? In other words, if a credit provider would list you as a slow payer, or they list you as somebody who's got judgment, what are the retention periods? In other words, how long can that information be kept on your credit report?
I think the question is a bit more complex than that. First of all, the 2014 amendment to the Act brought a whole list of additional things that credit providers must do before you can be listed, adversely listed on a credit bureau. So there has to be a procedure just followed, there has to be correspondence, and there has to be a procedure not only with the consumer but with the credit bureaus as well, whereby certain things need to be proven to the credit bureau before a listing will be done. So defaults, you cannot be listed on a credit bureau within 90 days of the first default. So you have to be in default for 3 months.
3 months at least.
A lot of credit providers use that as the soft collection window, you know, from first date of default to 3 months from default. So that is the period in which the consumer would be contacted and would be given the best opportunity to make the necessary arrangement and cure that default, because that is the most important thing. And if you look at the latest credit information out there, there are massive amount of defaults in 120 plus days, even 90 plus days.
Yes.
And a lot of that comes from COVID. If you look at the statistical analysis, all of us took a massive hit with COVID with regards to decreased income and the like. And a lot of people are still trying to cure that. So listings can only be done after 90 days, but there's a very big difference between a listing for a payday loan and on default on a payday loan, and listing on a default on a mortgage agreement.
Yes.
So, and obviously the rules surrounding the listings are very different. I think one of the most biggest changes, that the 2014 amendment brought was that with the judgment being removed after 5 years, that it falls off the credit bureau. Not the debtor doesn't become extinguished, it just falls off the credit bureau. And so does most of the other listings. In the olden days where there were a judgment, the consumer had to bring a court application to set aside that judgment before the removal of the adverse listing on the credit bureaus. Now, when a debt is paid up, the credit providers must, in terms of the Act, go and remove that judgment, which was never the case before, and which caused consumers that really could enter the credit market as active again was precluded from doing so. So I think the whole reform surrounding credit bureaus and the listing periods and the retention periods and so on had the purpose to reform consumers to come back into the credit market, as soon as possible. And as you know, that is in line with the sequestrations as well, and your rehabilitation period with sequestrations.
Okay, so let's talk about debt cancelling. What is the purpose of debt cancelling or debt review?
The purpose of debt review is to take your current debt, to extend the terms of that debt, in many instances reduce the interest to make your debt more affordable. So you will pay the same debt that you have now, and as we said before, as a credit provider you are fully entitled to recover your money. It is what it is.
Yes.
That's the purpose of your being here. And especially Old Mutual has been around for such a long time. It would take an installment and make it lower because it extends over a longer period of time. And as we said before, if you have enough money to get to work, and if you have enough money to feed your family, there is no need for you to go in default. So what the extension of term would do is bring down your repayment on your credit and put more money within your budget to look after yourself, and obviously within reason. I mean, it's not going to support your 2,000 Rand cigarette bill, and it's not going to support DSTV premium packages. I mean, there has to be a fair balance between making your budget for living higher, but still paying your credit providers within a reasonable time. Bad things happen to good people all the time, and we saw that in COVID, and it broke all our hearts. Where people's spouses lost their jobs, or hours were reduced or whatever, and life happens. And a lot of people under debt review today, it wasn't their fault that they are there, but it is a very, very effective method of dealing with your debt, because immediately credit providers are informed that you have applied for debt review. Those people are professionals that are trained, had to do a course and had to be registered, and they then look very closely at your budgets. They speak to your credit providers, and they negotiate a fair deal between you and your credit provider, so they become an intermediary.
Yes.
To use the word. Once there is an agreement between all the parties that the debt would be extended and what the amount would be, that matter then goes to either the consumer tribunal or goes to a magistrate's court, so that can be codified. That someone can't in 2 years' time turn around and say, "But I can't remember what we discussed." So those things are codified by a court order, and once the consumer has paid in terms of that order, it is removed. It is completely expunged. Not even if a credit provider goes into your profile then at a later stage will it even reflect on the credit bureaus, and you would be completely credit active again. Now, I think, John, what is left behind often is the word counselling, because it's called debt counselling.
That's right.
And when you look at a lot of recent judgments, judges are saying that counselling must be put back into debt counselling.
Yes.
Especially at my time at the regulator, you see that very often. You can quickly tell the difference between a consumer that has been counselled and a consumer that is not. And you would typically find that a consumer that was properly counselled during the debt counselling process, which is the purpose of a debt counsellor, would typically be very responsible after the debt counselling period has passed, they have received their clearances, and they would be very responsible with their money. Where counselling has not been done properly, you'd find that those consumers go back into the debt spiral and would be under debt review within a period of 2 or 3 years after receiving a clearance. But again, we go back to my initial address to you. It is absolutely the consumer's responsibility to take responsibility for their own financial position. But that also includes seeking the necessary help when the time comes. Like I say, when you have to start borrowing to pay debt.
From Peter to pay Paul.
Yes, I think you need to sit down and you need to be honest with yourself and say, you know what, I'm hitting the debt spiral. And we've all seen what happens. I mean, there were studies in India on suicides. We all know of recent suicides of prominent people surrounding debt. And you don't have to go there. I mean, there's the help for you. Go speak to your credit provider. Always keep your credit provider abreast of what's happening in your life. They will go out their way, in my experience, to help you. And then there are other people like debt counsellors that can assist.
So before we conclude with the debt consolidation and reckless lending, just one last question around debt review or debt counseling. So can the application, or rather a person who applies for debt review or debt counseling, just that effort on its own, or a person haven't approached or consulted a debt counselor, can that process put a legal process, any pending legal process on hold in respect of that particular consumer?
It cannot. Remember, debt counselling was designed to ensure that within that 90 days, that soft collection time, that all the credit providers can be catered for fairly, and that nobody has to spend money. Because if you really look at what debt counselling is, it's a free debt collection service for credit providers. They don't have to have debt collectors. They don't have to people running with baseball bats and all sorts of stuff. That's when it needs to happen within that period.
Within that 90 days.
Because some consumers are just so deep in it that debt counselling is not a way out. Debt counselling is not for everybody, unfortunately. And especially where credit providers have now been forced to spend money to get lawyers on board and issue summons and foreclose on properties and so on. Wherever legal action has commenced on a credit agreement, it cannot be included under debt review. But there is a process as well. There is we call it a Section 129 letter, and it says it clear, Section 129, letter of demand from the credit providers. And in this letter, it tells the consumer, listen, you are in default for more than 20 days. You have 10 days to go and see the ombud of credit or banking or whatever.
Or the credit
if you have a query, if you're not paying because you have a query, go and see an ombud. If you struggle to repay, go see a debt counsellor. And it states it in so much words. And when a consumer gets that 129 letter, that's the time to start acting. Because if you are going to ignore that letter, then legal action will commence, because the first thing a judge will look at, or a magistrate, when they look at enforcement action against a consumer, is, was that demand sent?
Yes.
And did the time pass in which the consumer could act?
Yes.
So that could also be a very good time for consumers to say, you know what, let me either go and speak to my credit provider, or if that has been tried already, let's go speak to a debt counsellor.
So in other words, if you're a consumer and you know you are over indebted and you don't have enough money to service your debts, don't run away from your credit provider. Rather, proactively approach them, make arrangement, and so on. And should you receive a letter of demand, which you refer to as a Section 129 letter, is you need to act within that period. Because if you don't act within that period, once that period expires, should the credit provider decide to take legal action, at that point in time, it may be too late for you to stop the legal action. But you do have a chance if you act when you receive a letter of demand, or even before. You're correct.
Absolutely. And that is the purpose of it. You know, especially when you look at secured debt, like motor vehicles and cars and houses. You know, once that foreclosure procedure started, or the procedure started to go and attach that secured asset, they're not going to stop, because it's an extremely intense and costly process. Remember, with a car, every day that car is on the road, it loses value. I mean, the moment it goes off the showroom floor, it loses half its value. I mean, we know that. Especially with bonds, they much rather recover the property as soon as possible, you know, recover the capital and redeploy that capital as soon as possible. Because every day that agreement, especially for secured and mortgage, are in arrears, it loses value.
What are the advantages and disadvantages of debt consolidation?
Again, debt consolidation is not for everybody. Debt consolidation can only work if the aggregate average of the consolidation loan is substantially less than the aggregate average of your debt that you currently have. It doesn't help that your current debt, if you take the average interest rate that is charged is 20% or 15%, and you get a consolidation loan that consolidates all the different loans in one, and you pay a 25% interest rate. That is 10% more than the average aggregate of your current debt. So consumers need to be very careful and do the mathematics. I mean, there's a lot of calculators on the internet for free that you can use, especially for consolidation of loans. And consumers need to make absolutely sure that the consolidation of their debt, which is not debt review. Debt review is not the same.
Yes.
Consolidation of debt, the interest rate that you receive in the consolidation loan, there has to be substantial reduction in the aggregate average interest rate that you have for your current debt. Otherwise, it's not an answer for you. Getting all the debts, a consolidation debt will then take the value of all your debts, will actually go and physically pay them off, so they'll be paid off, and you owe a debt to only one credit provider. You would pay one installment and you would pay one interest rate. But again, do the math and make sure that interest rate is substantially less. I mean, substantially, I mean at least 4 or 5% less than you would have paid in interest. And then also there's an issue of costs. Credit providers are allowed to charge you a monthly fee for credit that they have with you. And if you have 6 agreements, you're paying 6 fees. If you have 1 agreement, you pay 1. So do the math, but make sure that it is a proper solution for you in rands and cents terms.
Okay, finally, last question. What is reckless lending?
I did my thesis in my master's degree on reckless lending. It is where a consumer is given debt that they cannot afford to repay. Now, in my thesis, my first question that I asked was, you know, what type of business model from a credit provider would work if you would borrow money to a person that you know you're not going to get back? I mean, it doesn't make any sense. So let's dig a bit deeper and see where we go. And reckless lending, I think, you know, from the more established credit providers, has become reputational. You know, so if you have been, as the credit provider in a court, found you know, guilty of reckless lending, it would cause severe reputational damage for you, and it mostly disappeared, you know, from the larger credit providers. But we all know Mashonisas. You know, they're not registered. They keep your cards and they keep your pins and they keep your SASSA cards and all sorts of stuff. And that would be a very easy way to explain it. That you are giving credit that you cannot repay while be able to look after yourself. And it's quite an easy calculation. And there's 3 types of reckless credit when an agreement can be found reckless by a court. Remember, when a debt counsellor look at reckless credit, they can only make a recommendation. They can't say, I believe this is reckless, or say that this is reckless. They're not a magistrate. They can recommend to a magistrate with facts that an agreement be declared reckless. And that would only be in 3 circumstances, where the credit provider did not do a credit check on you, I mean, if they didn't do a credit check, they didn't look at your affordability. They didn't look at what debt you currently have and what means you have to repay. If the second one is if that loan actually made you over indebted. So you would do a calculation and see that after your expenses for the household has been reduced, that you can actually afford to repay that. Okay, and the third one is if you did not understand what the credit is and what you're getting yourself into. Now, there's a lot of case law on the first two. There is not that I know of any case law on the last one that people did not understand. But that is really what reckless credit is. Your debt counsellor again is properly trained on how to do those calculations, and credit providers, in my experience at the regulator, these things happen. You know, sometimes, you know, a button was pressed that shouldn't be pressed, or an amount was put in a computer that shouldn't have been, or extra note was put in, and the credit providers would be very quick to jump in and say, you know what, actually we see that there was a genuine mistake,
and they can be fined for that.
Not fined as much, but they could be punished by the court. And what the court could order, as an example, is to say to them, well, all the other credit providers must be paid first, and you will wait until everybody else is paid before you get anything, and you can't charge any interest. Okay. So, fined, not really. Punished, yes. Okay. And obviously the reputational damage that goes with that.
Yeah. Well, Tim, thank you so much. I mean, this has been very, very insightful. I mean, we discussed all things credit, and if anybody hasn't learned anything after this, then I don't know what will. Thank you so much, and we really appreciate your insights and your experience in dealing with these issues. Thank you so much.
John, it's always nice to be with you, and thank you for this opportunity.
Thank you very much.